So, how can a judge possibly rule impartially on a historic criminal trial when his own daughter's consulting firm is pulling in millions of dollars from the defendant's biggest political rivals?
It's a huge question. And today we have the documents to dig into it.
We do. We've got a stack of federal election reports, judicial ethics analyses, and maybe most important, the detailed testimony from a recent congressional hearing.
The one focused on the alleged weaponization of the federal government.
That's it. Okay, let's unpack this. Our mission today is to really distill the facts around this conviction and, the concerns it's raised about the rule of law itself.
And that starts with some truly explosive figures. I mean, the numbers here are what really kickstarted this whole debate.
So we're talking about Judge Juan Merchan, who presided over the trial, and his daughter Lauren Merchan's firm, Authentic Campaigns. What are the headline numbers that got Congress's attention?
The big one, the one that puts judicial impartiality front and center, is $12.7 million.
Wow.
That's how much her firm took in from high-profile Democratic clients in just the first 6 months of 2024.
The first half of this year. So right in the middle of the trial and its immediate aftermath.
Exactly. And you have to look at the timeline to really get the full picture.
Okay.
That $12.7 million, it represents an 86% increase in revenue for her firm compared to the same period back in 2022.
An 86% jump. And 2022 was just before Judge Merchan was assigned this case.
Shortly before, yes. So that, that exponential growth tied directly to the defendant's political opponents. That became the absolute core of the ethical debate.
Let's get more specific about these clients, because we're not talking about small-time donors here.
No, not at all. These are major political players. The top client was Congressman Adam Schiff.
Schiff, who led one of the impeachment efforts against Trump a few years back.
The very same. His campaign paid the firm almost $8 million this year alone.
$8 million for what? Digital consulting?
Digital consulting, ads, that sort of thing, all while he's campaigning for the Senate.
So you've got a leading political opponent of the defendant paying the judge's daughter's company $8 million during the trial.
Precisely. And he's not the only one. You have Congressman Dan Goldman, who once said publicly that Trump has to be eliminated.
Okay.
His campaign paid Authentic Campaigns $57,000 this year for digital ads.
And it wasn't just existing clients, right? I saw a note about Michigan's governor, Gretchen Whitmer. Correct. Her Fight Like Hell PAC started paying an $8,000 a month retainer for digital consulting.
Let me guess the timing.
3 months after Judge Merchan was assigned the case. April of 2023.
It's a pattern. I mean, with those numbers, it seems like the defense had no choice but to ask for a recusal.
And they did. They formally requested it back in May of 2023. They argued that, and this is a quote, the daughter's close connection to President Trump's political adversaries created real and legitimate concerns about this court's impartiality. But the judge said no. He stayed on the case. What was his justification?
He pointed to an ethics opinion from the New York courts, Opinion 2354.
And what did that say?
Basically, that a judge doesn't automatically have to recuse just because a family member works for a firm whose clients have interests opposite to the defendant. The thinking was that the money wasn't going directly into the judge's pocket.
But critics, including other judges who testified, said he was missing the entire point. He was looking at one rule while, ignoring the spirit of another.
The impartiality might be reasonably questioned rule. It's New York's Rule 103E1.
Right.
And that's the gray area. It's all about the appearance of impropriety. A former judge, John H. Wilson, made this point very, very clearly in his testimony.
Wilson was quite blunt, wasn't he? I read that he said Merchan should have known better than to even make small political donations himself.
He was. And his point was that this was on a whole other level. The sheer scale of the financial benefit flowing to his daughter tied directly to the defendant's political enemies. It creates an appearance problem that, you can't just ignore.
So the argument is that public trust in the process just gets shattered.
Exactly. When the public perceives that the judge's family is benefiting, even indirectly, from a conviction, that trust is gone. That's the real takeaway on the conflict of interest side.
Okay, so that's the massive financial cloud hanging over the court. Now, let's look at the prosecution's case itself. Here's where it gets really interesting. Critics call it lawfare, arguing the whole legal theory was, sort of, manufactured for politics.
That's the core criticism we heard from the legal experts at the hearing.
So how did they turn what's usually a misdemeanor into a felony conviction?
Through a process they call bootstrapping. The basic charge, falsifying business records, is a minor misdemeanor in New York.
Right.
To make it a felony, prosecutors had to prove the records were falsified to hide another underlying crime.
And that underlying crime was supposed to be a violation of federal election law, or FECA. But this bootstrapping idea itself was heavily criticized.
It was. Judge Wilson, the same former judge, testified that the indictment was legally insufficient from day one
Why?
because it didn't actually name the underlying crime. Think about that for a second from a due process standpoint.
So the defendant is facing a felony, but doesn't officially know what the real crime is that makes it a felony?
Correct. The prosecution didn't reveal their specific theory of the underlying crime until after the trial had already started in their opening statement. The defense argued they couldn't possibly prepare.
That seems like a fundamental problem. But let's get into the substance of it, the supposed FECA violations. The federal experts who testified had a very different take on this.
A profoundly different take. This is where Professor Bradley Smith, a former chairman of the FEC, gave some really powerful testimony.
And he's the guy who would know.
Absolutely. He argued pretty unequivocally that under federal law, the payments at the heart of this case were simply not campaign expenditures, period.
Which, if true, completely gets the prosecution's entire case.
It strikes at the very heart of it. And he pointed out that the two federal agencies that actually enforce these laws, the FEC and the Department of Justice, both looked at this exact fact pattern years ago and declined to bring any charges.
No civil charges from the FEC, no criminal charges from the DOJ?
None. They both passed on it.
Okay, but a fair counterargument might be that state prosecutors can use novel theories, right? Just because the feds passed doesn't mean it's not illegal under some state interpretation.
That's the argument the DA's office made. But Professor Smith's testimony also poked a huge hole in their central theory of why it was illegal.
Which was what?
The prosecution's whole story was that the records were falsified to hide the payment from voters before the 2016 election, to interfere with the election.
Makes sense on the surface, but what's the flaw?
The timeline. Smith pointed out that even if you treat the payment as a campaign expense, which he disputes, FECA rules would not have required it to be disclosed until after the election was already over.
Wait, really?
Really. So if there was no legal requirement to tell voters about it before the election, then the entire motive, the whole theory that this was a cover-up to trick voters, it just collapses.
And on top of that, there's the whole idea of this being a fraud case.
Yes, another former prosecutor, Jonathan Fahey, testified that it's just unheard of to bring a fraud case where nobody lost any money.
No victim.
Right. The accounting entries were internal to a private company. Everyone involved understood what the payments were for. Fahey's point was that if you strip away the politics, you're left with a case where the feds said no, the legal timeline doesn't work, and there's no actual financial harm to anyone.
This brings us to the trial itself. Critics argue Judge Merchan made a series of rulings that were, highly prejudicial.
And in one case, maybe unprecedented, the biggest point of contention was the jury instructions about unanimity.
This is the part that I think is the most shocking for people who aren't lawyers.
It's critical. Judge Merchan told the jury they did not need to be unanimous on what the underlying crime was.
So just to be clear for everyone listening, the felony required hiding a crime. The prosecution offered 3 possible crimes, and the jury didn't have to agree on which one it was.
That's it. You could have 4 jurors who thought the underlying crime was a state election law violation, 4 who thought it was tax fraud, and 4 who thought it was a federal election violation.
And that still counts as a unanimous guilty verdict for the felony.
Yes. Judge Wilson called it an extraordinarily egregious error and said it was something you just don't see in American felony trials. It led to what he called an inspecific verdict.
Because you can't actually be sure that 12 jurors agreed the defendant committed any one specific crime.
You can't. The instruction, critics argue, let the prosecution paper over the weaknesses in their case and get a conviction without the constitutionally required level of certainty.
The other major point from the hearing was about the witnesses. A serious imbalance.
A striking imbalance. On one side, the judge stopped Professor Smith, the former FEC chair, and a top expert from giving real testimony on campaign finance law to the jury.
What was the reason?
He said it would confuse them.
Confuse the jury. Okay. But on the other side...
The prosecution's star witness was Michael Cohen, a convicted perjurer, someone who is admitted to lying to all 3 branches of government.
And he was allowed to testify about
these very same campaign finance issues, despite having 0 expertise. So you had a situation where a real expert was blocked, while a convicted liar was effectively allowed to act as an expert for the prosecution.
The pattern that emerges from all this testimony is one where political motives seem to drive everything from the DA who literally campaigned on going after this defendant to these very specific, controversial rulings in the courtroom.
And Professor Smith warned that this sets a very bad, very dangerous precedent. It threatens the entire bipartisan system of federal campaign enforcement.
How?
Because if this verdict stands, it basically gives a green light to any local prosecutor, anywhere in the country, to bring charges for supposed federal election violations, even when the FEC and the DOJ have found no wrongdoing.
So, what does this all mean for you, the listener? Let's recap. We have sources detailing massive financial gains for the judge's daughter from the defendant's political opponents. We have a novel legal theory that federal authorities passed on. And we have judicial decisions that critics say gutted due process.
It's that convergence of things. You have political motivation from the DA, a clear judicial conflict of interest that the judge dismissed, and a creative legal theory that sidestepped the federal agencies actually in charge. For critics, these elements combine to paint a picture of a justice system being used for political retribution.
Which leaves us with a final, provocative thought. If a major political candidate can be subjected to a state prosecution built on a legal theory that federal agencies rejected, presided over by a judge with a clear conflict of interest, and convicted with a non-unanimous verdict, does this set a new, dangerous standard not for political accountability, but for political warfare in America? And what does that mean for the next election and the next political opponent, regardless of party? It's a question that cuts to the very heart of the rule of law.